Okay, there we go. Good afternoon, everyone. This is Curt Barone.
This is Brad Pinsky.
All right, and here we are for another edition of Fire Law Roundup for March 6th of 2023. Brad, go ahead. Take us away.
Okay, well, geez, Curt, you and I were just at a conference, and I don't know how many times this one came up, but I was teaching a lot, at least in some of my sessions, I was teaching a lot about how not to allow other people to steal. And here we go. We have yet another treasurer, not surprising, stealing from, in this case, a North Carolina fire department, and she stole $48,000. I do this every time we talk about theft. I mean, these are the way she stole are the two easiest ways to prevent. She stole from writing checks directly to herself. So that tells you nobody is checking. And I'm sorry, I'm not trying to be hard on the department, but come on, this is enough already. And she was writing checks directly to herself. That should have popped right out. She also took cash withdrawals, and had they looked at a bank statement, that would have popped right out. So I'm not blaming, but I'm just saying that these things are easily preventable if we would just look at the bank statements and perform internal audits. You point to a friend of yours who points to pink collar crime. This is another female who stole. And I think statistics say that for some reason it's more women than men who steal. I don't know why that is. But
well, yeah, no, it's not actually that. It's just that I think we all have a bias. And this is where I think the crux of the problem is. Number one, we have a bias in favor of other firefighters, and we trust them. And we feel that they would never steal from us, that they're above board and they're above reproach. So that's sort of bias number one. Bias number two, and I think what you're getting at here is that we tend to think that people who steal are more likely to be men, that men are more likely to steal, women are less likely to steal. And that's not accurate. It's not that they're any more or less, they're the same. And right. When we make the assumption that they're less likely, we tend to put less checks and balances in there to identify these things and prevent them from happening. And you're absolutely right. I mean, she was only there. You look at it, I included that in the post there. And again, this is the Pierce's Mill Fire Department, okay, in North Carolina. She had only been the treasurer there since July of 21. So she stole almost $50,000, or she's accused of stealing $50,000 in a little over 18 months. So, my assumption is she got in there and pretty quickly realized, hey, nobody's watching the hen house. And maybe there was an expectation that she would be the one that's watching the hen house. But at any rate, we see it once again, and it is all too familiar. But again, one of the things that Kelly says, and again, Kelly Paxton from Pink Collar Crime, is she said a man is more likely to rob you. If you think about getting robbed, no, think about it, right? A male is much more likely to rob you, whereas a female is much more likely to embezzle, forgery, and those types of things, okay? And also another thing is a male is more likely to take a large amount all at once.
That is totally consistent with what I have seen over the past couple of decades, no question.
And females are more likely to take a little bit and a little bit and a little bit. Some of them, Kelly's got a number of case studies where people have stolen, like a secretary or a bookkeeper has stolen, $25 a week for 20 years.
Yeah.
And varying amounts, but that's some of the differences. But it may be, and I can't even say it's more likely a woman is more likely to embezzle. Kelly would have that kind of information. But the point is, we've got to recognize our own bias. Okay. And our bias is usually in favor of firefighters, number one. And number two, and I can't speak for everybody, I can speak for myself. I have a bias that supports women, that believes women are less likely to do this. And we've got to overcome that and recognize that anyone under certain circumstances may steal from us, and we need to have precautions put in place.
Right. And let's be fair. when people steal in fire departments and ambulance services, it's always the person we trust. Right. The person who steals from us is always the person we trust, because we treated them like we didn't trust them. Then we would be conducting internal audits and always. So nobody should be shocked that it's the person we didn't, that person who stole from us and we trusted them. You should be like, oh my God, I didn't see this coming. You should always see it coming and put in internal audit procedures. And they're so simple to do. If you just review the bank statements and you compare the checks, the front and the back of the checks, and you compare it with the bill, you can prevent this. And if you set it up in a notebook where it goes in check order and you put every return check, staple it to the voucher and to the invoice, and you compare it, you can audit every month in probably about 20 minutes, 15 minutes. And if you do it every month, it's a manageable project, but everyone has to do this. And I caution people, I know everyone thinks, oh, we have insurance if somebody steals, but all of those insurance fidelity
it's not going to help you reputation wise. You can have all the reputation and
donations and tax money. Nobody necessarily feels bad for you because you let it happen, but you better be careful with insurance, because the insurances have a disclaimer: if you knew or should have known. And the failure to conduct audits is you could have or should have known. And if you weren't looking, they could disclaim on insurance. And by the way, everyone should check their fidelity coverages, because a lot of these are like at $50,000. She got caught right up to that limit, but we've seen 1.5 million. We've seen 5 million. We've seen all sorts of ranges. So this is nothing new, but we have the same discussion. We should just hit replay every single time.
And let me make my point. One of the things that, because I've been dealing with this now since I first became aware, roughly 15 years ago, I first became aware that this was an excessive problem for the fire service. And so I reached out to a number of different people, Kelly included, but some other people as well. And they said, if there's one thing that you could do, it's to make sure that all of your account statements are mailed to someone other than the person who has check writing authority or credit card writing authority. Because if they can write the check and they can intercept it, it'll never get to the audit committee.
Right. And of course, now we have online banking. Just give the entire board of directors online banking access to be able to view. They don't have to be able to, cut checks, but to be able to view at the very least.
One of the other challenges here is that, especially in a volunteer organization, nobody wants to do this. Nobody has the time. Firefighters join the fire department in order to go on responses. They barely have enough time to do that, fulfill their training requirements. And now we want them, a small group of them, to come together monthly and do the audit. Okay. And I hear that a lot when I try to convince my clients that they need to do this. The thing that they're neglecting is that when you are an elected officer of a corporation, whether it's a fire district or whether it's a volunteer fire company, you have a fiduciary duty. And when you don't satisfy that fiduciary duty, you can find yourself personally liable for this as well. Okay?
And you just did such a nice plug. I don't know if you know this yet, but our law firm does, I'm going to do a little bit of advertising, which I never do on our site here, but our law firm does a ton of financial record keeping for fire departments and ambulances and fire districts. We got so busy that we've had to now split it off into a new company. So I'm excited to announce the launch of a company called Fire Service Financials. And if people want to see, we have a rate schedule. We keep financials and we review all of the bills and receipts for this exact problem. It's too hard to get treasurers who know how to do this. They don't provide the proper monthly financial reports, and there's a lot of them. They don't know how to fill out a 990. So we launched fireservicefinancials.com, where we are keeping records. We've been doing it for 20 years, but we just got so busy we had to kind of put it over to another company. And
is Nicole handling that?
Nicole is in charge of it. Yeah. She's been for 2 decades doing financials for fire departments, ambulances, et cetera. She's good at it. And when she does it, she reviews the receipts and the vouchers, the disbursements, because we're not labeling anything as what it appears to be unless we can establish it. And then once we do that, then we provide the financial report. So it's an unfortunate realization, exactly as you said. that it is very tough to get a qualified treasurer in place. But we think this is an important step. We think it's important for the fire service. You know, accounting is too hard, frankly, and using QuickBooks is not that easy. You still have to know the accounting principles. And so we decided we're going to go national now. We were doing it in New York, but now that we want to expand nationally, we've separated off. So if anyone's interested, go to fireservicefinancials.com. This was not intended. Obviously, I didn't know this was
I wasn't even aware of it. And I spent the whole weekend with you. And but that's good.
We've just launched it, planning for it, but now we're going nationwide. Okay. So
more on that. More on that
later. To come. I'll put up little advertising banners on your site. Let's go to Louisiana. Not Louisiana. For everyone who wants to say it's Louisiana. I went to Tulane, so I'm going to say Louisiana. This is, I think, a good nationwide holding. I know it's related just to the statute, but I think it's very, and even the court kind of looks to other courts. So let me tell you what happened here. So we have a Louisiana Court of Appeals, so a higher court, has reversed a lower court, which is good because the holding at the lower court was very disturbing. We have a firefighter who was diagnosed with NK/T lymphoma, right? A fairly rare disease. And under the Presumptive Act, the employer has to pay. In this case, I think it's after 10 years. If you're on the job after 10 years, then there's a rebuttable presumption that if you get certain types of cancer, and this was one of them, that it's related to the job, and they have to pay you certain benefits. But the term rebuttable presumption means, right, for everybody, if as long as the person requesting the benefits has made a good faith basis to say why I'm entitled, such as I was on the job for more than 10 years, which does it, and I got cancer, right? That's enough for them to do. Then the burden shifts to the employer to argue that, no, it wasn't caused by the time on the job. It was caused by something else. And what happened here is, I think, extremely important for all fire departments who have these cancer, statutes, presumptive cancer statutes across the nation. The district court, which is reversed, but the district court puts on a couple of doctors or listens to a couple of doctors. None of the doctors could 100% say that this cancer could not be exacerbated, not caused, exacerbated. So your risk of getting this cancer, they couldn't say 100% could not be exacerbated by time in the fire service. And they said it's not likely, it's highly unlikely, we've never seen a case of it, there's no proof for it, but no doctor could say it's 100% not caused by exposure to other chemicals, which fire departments are exposed to. So based on that theory, the Court of Appeals reverses, placing a burden, a good burden on the municipalities, right? It's a new rule, as I interpret it, a new interpretive saying, no, you've got to prove 100% that it was impossible for anything in this case, 30 years, but in the minimum 10 years to have increased their chance, not caused it, but even increased. So if you're an employer and you're going to argue, at least in Louisiana, but I'm going to argue in now many other states, this case really does the firefighter justice, right? Even if it increased the exposure chance by 0.25%, that's enough to defeat the shift burden presumption or a shift burden's defeat, I guess, to the employer. So this was a great case, and whatever else you want on this.
Yeah.
But
well, I feel strongly about this, that cancer presumptions are the right way to go. I know many people say, how are the taxpayers supposed to be responsible for this, and so on and so forth. But the bottom line is, when someone gets cancer, there's going to be economic harm, period. There's going to be, now, whether or not it's going to be borne by the fire department, whether it's going to be borne by the member and his family, whether it's going to be borne by the taxpayers again, because the person is basically exhausted all of their resources and now is on some sort of federal financial assistance, Medicaid, Medicare, whatever it may be. The bottom line is someone has to pay for it. So who's in the better position to be able to pay for it? Are we better to put it on the federal government? Are we better to put it on the individual employee who likely could end up bankrupt and from medical bills? Or does it make sense to put it on the employer who then can insure for it and address it that way? And I'm making the case that it really should be the employer that is doing that. Now, the other thing is the science behind it. I think that there's cases, there's research that goes both ways. Some research says cancer is no more common in firefighters or just marginally higher in firefighters. There's other research that suggests that it's substantially higher. Okay, so point being, there is no doubt that firefighters are exposed to carcinogens. Okay, there's absolutely no doubt. You go to a car, even a car fire or a dumpster fire, never mind building fires, you are absolutely positively exposed to carcinogens. And so there's sort of a bargain there that you're saying, all right, look, you're going to go and think about this from a business perspective. Okay, I'm going to hire somebody and I'm going to expose them to carcinogens on Monday. And then I want them to come back to work Tuesday. Well, they got exposed Monday. How do I induce them to come back to work Tuesday and get re-exposed, and then Wednesday, and then Thursday, and then do it for 30 years? So the part of the bargain here is that, look, we're going to expose you during your course of your career. We're going to do everything we can to not expose you, but the bottom line is you're going to be exposed. Part of the bargain here is going to be that if in the event that you get cancer, we're going to cover you. And I think there's a strong economic reason why this makes a lot of sense.
And you said it perfectly. Yeah, you said it perfectly. And for the employers to cry, oh, it's too much for me. Wait a minute. Well, then you get cancer. Right.
Right. And if it's too much for you and you're running a business, how can you dump it on your employee?
Right. That's exactly. That's like GM.
They're not millionaires. They wouldn't be working for you if they were millionaires.
Right.
Right. So, how can you say it's too much? And you can plan for it. You can insure for it. You can add it to your workers' comp coverage. You're going to pay a little bit more an hour, but there's mechanisms in place for you to absorb that kind of increased cost.
And look, the most governments that I've seen, New York has, and I've read a lot of the others that have these presumptive cancer laws, they do something that's unfortunate for the firefighter, but they take a halfway point. For example, in New York and many others we've seen, they say, listen, you can only file a claim once within the 5 years after you've left the fire service. So if you've left the fire service.
Yeah, because you and I talked about this last week or the week before.
Yep.
And I noticed that you've got there's a link in there. You can click on it for the folks who are listening and go right to the Louisiana law, but it has that 60-month, 5-year limitation to it.
Very common. And that's just a recognition that, listen, we want to give you something, but we're not going to do it forever. So, you get a firefighter who joined at 20, retires at 45. If they don't see the cancer they got by age 50, they got 40, 50 years of life left. They're on the hook for it. So it's not like we're doing a huge disservice to the employers. The employees aren't covered for that long, unfortunately.
Right.
So, okay, let's go to, we're going to go to the Ninth Circuit to Seattle. This is really, interesting as well. So here, this is related all to the George Floyd riots, just to put people in context here. There was the mother sues. She's suing because her 19-year-old special needs child, right? Not a child, but he was shot and killed and I'm going to describe where he was shot and killed, but he was shot and killed in 2020. And just to put it in context, the what she's alleging is I was deprived of my son's life. And as a result of the government's failure to take proper action or their deliberate indifference, they deprived me of my son's life. So the court doesn't have a problem with that legally. So let me talk about the facts. Basically, the facts are after the George Floyd riot, the rioters took over an area of the city and they form, I don't know what it stands for, but a chop zone.
Yeah, they call it chop. I forget also, but
yeah, I don't know what it is.
Some name for it, but
they basically said, and I'm shocked the city allowed it, but they basically said there's no government here. In this zone, there's no city government, right? So the rioters, which, I'm going to regret saying this, but I feel like they say they got what they asked for. They want no government services. They should have gotten no government services, but that's not totally what happened. So in any event, and they had some rules in this chop zone, right? No guns are allowed. These are supposed to be peaceful protests. So this woman's son, special needs man, goes down there, has a negative engagement with somebody. That person then shoots him, and they move him to a special needs or to a medical tent. Outside the tent, the city, about 15 minutes away or so, placed an ambulance. But outside this zone, they placed an ambulance. So the city wasn't ignoring what was going on. The people call for an ambulance. There's some miscommunication about exactly where the patient was. And so after 15 minutes or so, I think they just throw him in a truck, take him to the hospital, and he's pronounced dead. So she sues, saying, listen, you were deliberately indifferent to the needs of my son and those people in the chop zone. And the court comes out and says, listen, and really slams the city. So much so when you read the decision, you think the city's going to lose. They said the city, allowed a dangerous condition to take place and really lambaste the city, but says, however, as to the 1983 claim for deprivation of life and property, right, the son, there was no deliberate indifference because there was a miscommunication. And they also said, listen, they were almost going to the public duty doctrine, special duty doctrine, where they said there's no duty really owed to that individual. They may have been deliberately indifferent or unintentionally negligent, whatever, to everybody there, but they didn't owe him a special duty. They didn't really go to that, but that's right where they were. And they, he really slams the city in his decision, but then says, we're not finding against you because we just don't think your conduct what rose to the level. He says your conduct was egregious, but it didn't rise to the level necessary to establish a 1983 claim. So that's really what it is. The facts are more interesting than the law, I think, on this.
I think so too. I've been following this case since it was filed, and I thought it would raise some interesting issues. But here the firefighters wanted to respond. They checked with the police, and what we call, I know in Providence we call it staging. You're staging for the police. By your policies, you're not permitted to go in unless you have some sort of security escort to go into a relatively unsafe area. So they were staged. They wanted to go in, and they did in fact go in, except by the time they got in there, he had already been transported, with a civilian vehicle. But I really like the fact that the Ninth Circuit added that, and I have it boldface there, but I'll quote the Ninth Circuit. It is at the ballot box that Sinclair, and that's the mom, and other Seattleites must hold the city accountable for their deliberately indifferent actions. So they are saying that there was deliberate indifference. It's just that the medics were not deliberately indifferent. Right. The city may have been deliberately indifferent, but it wasn't the city's deliberate indifference that was the proximate cause of the shooting. That there wasn't enough of a connection. So there's really two allegations here. One was that the Seattle Fire Department was deliberately indifferent by having the staging policy, and the court disposed of that. The other was that the city was deliberately indifferent for allowing the chop zone to be created. The court kind of said, you've got a point there, but that wasn't the proximate cause, wasn't really what led to the death of the young man.
Right. And I'm impressed with this because one of my frequent criticism of judges and courts is that they allow the facts to drive the law. And that shouldn't ever be that. Here, right, the facts, they said it's egregious. So normally I would see a court saying, I don't care what the law is. The fact that it's egregious, I'm going to create some law or ignore the law. And that's not uncommon. Here, I like the fact that they stuck to the law and said, I'm sorry, you just don't meet the requirements of a 1983 action, despite the fact that the facts are egregious. That is not overly common, maybe more common for the federal appeals courts, but not overly common for judges. I normally find judges' emotions lead the way.
Yeah, I think judges are intellectuals that find ways to rationalize a case coming out the way they have predetermined that it needs to come out.
Yeah,
That's
and
just
I
my.
apologize to all the
Yeah,
judges
no.
we're insulting, but then
Yes, I
don't do
know,
it.
I know, but
Prove
I
us
think
wrong.
they use
Prove us
that
wrong.
brilliant intellect sometimes to rationalize an emotional decision that they've sort of prejudged on. So
Right. Okay, let's go to Massachusetts. Massachusetts, however you want to say it,
Massachusetts.
So here, not the most groundbreaking decision, but it is certainly interesting. You had a very well, I think we talked about it, or you spoke about it, a civil service exam, which was denied basically to be, or the exam was thrown out because the results were discriminatory, right, against minorities. And so
if you want, I'll take the lead because I'm pretty familiar with this, and this has been going on for a while. But first of all, let me say, if you're not from Massachusetts, don't do what Massachusetts does. Okay. Massachusetts has this wonderful statewide civil service system, which in some ways is good because it takes the burden off the local fire department to come up with your own exams, but you're giving up so much by letting the state run your promotional system for you. Okay. But at any rate, we have a civil service exam that was supposed to take place in, I think it was March of 2022. The individual is a captain with the Boston Fire Department, and he would have been ineligible for that exam. The city, for whatever reason, it wasn't clear to me, but the city postponed the exam once. Okay, and they rescheduled it for November. He still wouldn't have been eligible because he was a lieutenant. He had just made captain. So and as a captain, he wanted to sit for the district chief's exam. And I think he had about a year or so as a captain, and I think he needed to get to 2 years or whatever it would have been. Bottom line is he's not allowed to sit for the exam. Now there's a court ruling that strikes down the way that the Mass Civil Service system has been developing their exams and their use of multiple choice exams. So you have this case, the case is Tatum versus Commonwealth of Massachusetts. Okay, so that case basically puts the civil service system back on their heels. They have to postpone, cancel all of the exams. They got to go back to the drawing board and come up with a new exam process that is not going to have a disparate impact on minorities. Okay, so now the Boston exam, this district chief's exam, gets pushed back, and it's rescheduled for in a couple of weeks, March 25th of this year. At that point, the captain would be eligible. So now, once they announce the date, he puts in for the exam, and they tell him, "Sorry, you can't, because we're only going to let people who were eligible for the exam a year ago sit for the exam." And he said, well, that's not fair, because the people who were eligible then, some of them have retired, some of them have moved on. Now there's a smaller pool, and I'm being denied the opportunity to test for that position. And by the way, the civil service regulations say I have a right to it. So he filed the suit. First of all, he went through civil service and they turned him down. So he filed suit and asked the court to allow him to be able to sit for the exam. Okay. And I don't know if you want to.
Sure. I mean, the court goes on and says, listen, they recognize it's unfair, right? Could be unfair, but basically they said, he wasn't eligible at the time, so we're not going to allow him. And this was a mere rescheduling. But the decision was, or the question was, whether it was arbitrary or capricious. And they cite the government's reasoning for limiting who could sit for the exam to the original qualifications. And they said, listen, that wasn't arbitrary. It may not be right, but it's not arbitrary. That's a tough standard. They also noted that he wouldn't have been eligible, right? They went through, he wouldn't have been eligible anyway. So it didn't really matter. But again, a government's decision, so everybody knows when you're challenging it, because this is going to lead right to the next case, the FDNY case we're going to get to, is whether their decision is arbitrary. Sometimes it's whether it has a reasonable or rational basis, right? They just have to have a good reason, basically. And it doesn't have to be the best reason. It doesn't have to be as long as a reason, a valid reason, then that's enough. Maybe there was a better way to go, but that doesn't matter. It just has to be rational. And so it's a very tough standard when you are challenging a government's action. And that's a nice transition to our next case, if you want to end there, unless there's something more you want to say.
No,
Okay,
this Mass Civil Service case resonated with me as someone who, I mean, I spent a lot of my time when I was with Providence studying, and I know for the folks out there that have to do that, you study for years and years and years, and even moving an exam a couple of weeks to a couple of months can change how many points, seniority points, and different things folks are going to be able to accumulate eligibility. And so I can understand a judge not really appreciating just what goes into the overall process. But at the end of the day, the way that it was interpreted was the civil service regulations give the Civil Service Commission some discretion. And that
broad
discretion
they said, broad discretion.
A lot of discretion, as long as the decision is not arbitrary or capricious. And capricious would be, for example, if someone involved in the Civil Service Commission's relative was in a position to benefit from the decision. Now we've got some different questions that come up. But other than that, other than something like that, they have the discretion to make that kind of decision.
Okay, so now under that perfect guise of what it takes to challenge, let's go to, again, something I think is super interesting. I don't think they have a chance in heck of winning, but, and today we got some decisions, right, or yesterday.
Yeah, well, they kind of came in over the weekend. I got them Saturday, and then yesterday the second one came in. But
okay, and they're good. They're a little bit helpful, but here's what we have. I could sum this up the best I can. So we have a bunch of FDNY chiefs who have been demoted. And these were of, I think, 18. I might mess that number up, but these were a large number of a very small number, right? There's like 11 or 7 of the 18, whatever.
Yeah, there were 3 who were demoted. Okay, there were 3 that were demoted. They were high-ranking deputy chiefs, but then there were, I think, 8 others or 5 others that then resigned their position, including the chief and the fire chief and the chief of operations, who submitted their resignation, not to retire, but to go back to their tested position of deputy chief. And I guess these guys were assistant chiefs. I'm sorry.
Yeah. And the ones who were demoted, I'm just reading, were 8 of the most senior chiefs, right? So,
so
and effectively there's only like 18 chiefs who could run incident command. And she just took a majority out. Now, they first say, let me kind of give an overview because it's kind of tough to understand. They're claiming this is retaliatory, and that A, it's retaliatory, and B, she has no experience, no background to make these decisions. Now, I think maybe the retaliation claim could stand, but I think they're going to find a rational basis. And I'll get into why she did this allegedly. But I think saying that somebody doesn't have the experience to do something and make a proper decision is, it goes back to, well, was it arbitrary or capricious, right? So what basically they said is, and they said this is abuse of discretion, but they said, listen, for example, there's an SCBA committee. They're going to need $50 to $100 million worth of new SCBA soon. So they formed a committee with a lot of very experienced people, and she took them all off, and she's going to make the decision herself. And she has no ability to make that decision since she's not a firefighter and has no fire background. I think that's a losing argument on that one, but they just provide that and other examples of what she's done. For example, she made a firefighter safety. She made that a civilian task, which is probably a bad idea, but
right here, let me point out, because I read that a little differently. Okay. And one of their allegations is that they're alleging they're being retaliated against.
Yep.
And they're being retaliated against because they point out that this is not smart. You don't take a committee with experienced firefighters who know what the firefighters need. You don't take them off the committee and then put civilians who have no expertise in this area on. So what they're saying, my reading of it is that they're saying that we were retaliated against for pushing back against her. That's
exactly what they're saying.
She's demoting us. So again, it's not so much that they could have been dead wrong. They could have been absolutely dead wrong, but they were just like a whistleblower could be absolutely dead wrong. But if they made the statement in good faith and subsequently were retaliated against, then you have a problem. That's where it's retaliation. So that's, they don't have to be right in order to prevail here. They have to show that they made a good faith they raised a safety concern, and as a result of that, they're being discriminated against.
Yeah, I could see that more. I think there's two components to this, but again, this is very long.
Right, there's several. Yeah.
To get most current, then we'll go back to more of it. To get most current, they asked for a temporary restraining order, which is very tough to get. Very tough to get. You have to show irreparable harm, immediate danger, and the federal district court came out and said, "Listen, you haven't met the burden of showing irreparable harm."
Let's talk about that, because I think that's one of the most important things, at least at this juncture, because I think everybody's familiar with what's going on. Hopefully, if you're not, go back and you can read the complaint, understand. But you've got a civilian commissioner who was never a firefighter, making some pretty serious changes, manpower, staffing changes, personnel changes in the headquarters ranks. And so you have this suit. One of the things that firefighters sought was a temporary restraining order. A temporary restraining order differs from virtually any other type of injunctive relief that a court can issue, in that you don't require the other side to come in. It's a one-sided type of thing. And what you've got to show is that things are so bad that we can't possibly give the other side an opportunity to come in and you can hear their side of it, that you have to listen to us and then issue this injunction to protect the status quo. So it's a very high burden. If you're seeking a TRO, classic TRO is in a domestic situation, where the victim comes into court and the judge issues the TRO only because there's no time to get the other person in, and maybe we can't even find them and so on. And that's really a TRO. They sought a TRO here, and I think that's a bridge too far here.
Yeah, the court says it's too speculative to satisfy the requirements that the threatened injury must be certainly impending, and things like, right? And look, I don't know. I mean, where I thought they would get it could have won this, right? Their strongest point, I'll go back to the lawsuit strongest point, but here for the TRO is, listen, we're not there to, 8 out of 18 of us, a majority of us aren't going to be on a scene to be a qualified incident commander under the FDNY's determination of who can run an incident. And we have major incidents every day. I would have thought that the district court sitting downstate, the district court would have said, that safety issue is significant, so we're going to put their demotions and et cetera on hold so they can keep running. It's a very high burden, but on that part where they're arguing there's very few qualified people anymore, when it's the FDNY who creates those qualifications in order to allow them to run incident command and limits it to 18 possible positions, I thought they might have had it, but the court says too speculative. So I was a little shocked, but I want to get back to something that I thought as we go now, no temporary restraining order. That doesn't mean they couldn't get a preliminary injunction, although it's not as likely, right? Because one of the parts of it,
explain what a preliminary injunction is, because I think folks may not grasp the difference between a TRO and a preliminary injunction.
Sure. So let's start at the end. What they're asking for is a permanent injunction, right? Or a reversal of the decisions of the FDNY commissioner. Before you get that, since lawsuits can take years, you can get a preliminary injunction that says during the pendency of this lawsuit, the FDNY is, prohibited from affecting these demotions, affecting transfers, et cetera. And that even to get through the preliminary injunction stage could be weeks or months or years. These are all recognitions that the courts are busy and things take a while. And so you can apply for generally ex parte, although New York's gotten rid of that. You have to at least have a phone conference.
Yeah, the TRO is the ex parte, but the preliminary injunction, you have to have the other side come in and they've got to be able to put their case on.
That's true, except I'm telling you that many courts, including New York and our federal courts, have said, we're going to get you on the phone. You have to give notice to the other side.
For preliminary injunction or a TRO?
TRO. TRO,
Well,
you
yeah, for
cannot.
TRO, but a preliminary injunction is like the next step in the process.
No, agree, which is fully argued, right, in paper. The TRO now is just argued on the phone, right? It's asked for in paper, right?
Mhm.
How it works is you file the preliminary injunction, right? Well, you file your
You
Article
file-
78.
Right.
And then you ask for, during the pendency of this matter, we would like this, we would like everything put on hold. And then you say, while we're waiting for the determination whether you're going to put it on hold, we want an immediate, very temporary, right? That's the TRO. But I'm telling you, the courts force you to get the other counsel on phone to have a quick discussion about it. It's not as formal as a preliminary injunction, which is fully before the court in papers and argument. But here, the TRO test is very hard, right? Immediate irreparable harm. The other part that they haven't discussed and probably wouldn't, but is a practical matter. You know, I've asked for a lot of TROs in my life. I get about 20% of them, right? If I'm guessing, they're hard to get. But you also have to post a bond for if you lose, and the bond has to. And I will guess what it would be here. The bond has to say, okay, if we lose, we're going to put up the damages. Now, what are the damages? Damages here could be, well, if we don't demote them, we're going to end up paying more money in salary. So I'm thinking the bond is probably for their salary. And now you're telling the people, look, you can ask for the TRO. You may even get the TRO. But if you don't win the case, you now have to pay back all of this salary and you have to bond for it. That's pretty scary. I don't know whether their lawyer explained that or not, but that's pretty darn scary. So I don't like asking for TROs when we can end up losing, or my clients could end up losing a lot of money. Better on the preliminary, which there's still a bond thing. But anyway, but here, one of the most interesting things that I think is the best case they have is they allege that they violated departmental procedures when she made these determinations because she didn't have, they argue, the authority, the rulemaking authority. I don't know. It's not by statute or regulation, I don't think. I think it's internal rules, but that they violated their own internal rules by having her make the decisions. Maybe when she was acting commissioner, it had to go up to somebody else, and they violated those rules. I have seen cases, I can't point them out, that say, listen, where you were arguing that somebody below you didn't have the authority and it had to be approved, the courts have come out and said, it doesn't matter. They know this lawsuit. They've tacitly approved it. They didn't do anything about it. It's their own rules put in for their own benefit, not yours, and they can waive their rules. So I don't know whether they'll come down that way on this, but violating departmental procedures to me is much stronger of a case than your decisions were arbitrary, capricious, or you don't have the expertise to make certain decisions, hence arbitrary. I think that's a very tough row to hoe to say, well, you're the commissioner, right, of the FDNY and you don't have the experience. My answer is, says you, because the city obviously found she did have the knowledge and experience to do it. And I think trying to say she's unqualified, fine. She didn't come up through the ranks like Negro and all the others, but, I think Daniel Negro came up as a chief and all that. She's the outsider, very much so, but that's what the city wants to do. I think it's a very tough case.
Yeah, I agree on that account. But I think the pinch point was that she made these determinations without including the fire chief, and the regulations state that she's got to make appointments after consulting the fire chief. She's got, they've got to.
And is it the regs or the rules, like statutory regulations?
That wasn't, I don't think it was statutory.
Okay.
And again, I think you're absolutely spot on there in terms of whether or not the court is just going to say they're her rules. And so, the city's rules and they didn't follow them, but that's not really something that gives you a basis to argue about. But again, I think if we go back to the retaliation part of it, that they raised safety issues. And as a result of them raising safety issues, she now has retaliated against them. There may in fact be some basis there. I think that's probably their strongest argument, but it's going to take a while for that. That's not the type of thing where you're going to get a TRO on.
No way.
And again, just to clarify here, we're talking about not incident command at regular fires, 1 and 2 alarm fires, but really there's a procedure for who's going to respond to 3, 4, and 5 alarm fires, and so
Which are every week.
Yeah, well,
every week down at FDNY. I mean, this isn't like it may happen, you know, like a train wreck, which apparently now is happening every week. But
in Ohio,
but these are
anyway.
big.
Yeah.
Yeah. And by the way, I don't want, if any FDNYers, because we've got a ton of them who listen, but if any of FDNYers are listening, Curt and I are absolutely not saying that we think this was right,
Yeah,
that we are agreeing with her decisions. We're not making any comment that we agree with her decisions. I personally, not that it matters as law, I personally agree with what they're saying. It does appear to be retaliatory. Now, of course, I don't know what the process was for them to complain. Maybe there's a rule that they want to enforce on how to complain and they violated it. Right. Maybe they should have been given hearings and disciplinary and all that. I'm not saying that we don't agree with their message, but as the lawsuit goes, this is a very difficult lawsuit.
It is. And if you take a step back from the law, it's a little bit concerning. There's a couple of things about the case. Apparently there was a chief's meeting and someone recorded it and then someone released it to the media. And it was released to the media in a way to make the chiefs who were in the meeting look bad. So, you know, that's not professional. That's political. That's the kind of move a politician makes. It's not the kind of move a respected and credible leader makes. So that's sort of you know, one part of this that you know, that is concerning. And the other is that there were public allegations made by the commissioner about the 3 chiefs and that they were bullying people. And, you know, funny thing about a bully is I've yet to meet a bully who realizes they're a bully. I've yet to, right? I've never met a bully who says, oh yeah, I'm a bully. It doesn't happen. Okay, we can always see things in other people, but we have trouble seeing it in ourselves.
Hard to bully your the people you report to, however.
Well, you know, but apparently there was some comment that she felt that these people were bullying their subordinates. So what did she do? She bullies them. I'm going to demote you, and I'm not going to give you the opportunity to make your case for keeping your position. I'm not going to tell you why. I'm just going to remove you. That's bullying. You know, so you're saying somebody else is bullying. So what's the solution? You know, and I get it. If you're dealing with a bully, I guess you have to kind of play your trump card. You have to, I guess, be a bully. But it kind of a little bit of irony there that she's accusing other people of being a bully, and then she pulls a bullying move on them.
And I fully sympathize with all of them. I don't side with the commissioner on this as a factual matter, but as a legal matter.
Yeah.
Tough case.
Yeah, I do. And again, I don't want to just completely dismiss the commissioner's position either, because I know sometimes as a leader, you have people who are just, they're not going to play well with you. They're going to try to undermine you. They're going to try to cut your legs out from under you. And I've been in that position at different points in my career where people have tried to cut my legs out from under you. It's not a very pleasant position to be in.
I well know.
You know, right. And I know I'm speaking to the choir. And so, but at the same time, you know, is that actually what's happening here? Or were those people raising legitimate safety concerns about some of her decision making, and that this is retaliation? So that's why we have courts, folks. That's what the courts, you know, we can speculate, but it's going to be up to the courts to figure out whether the commissioner was really dealing with insubordination in the ranks that she felt she needed to manage, or whether in fact she was a bully herself and was retaliating against these people who were, and I would be guilty of doing this if I was her subordinate and I felt she was making a mistake. I'd go toe to toe, and I commission, when we walk out of this room, everyone in the world is going to think we agree. But until we walk out of this room, I am disagreeing with you. This is a mistake. You should not be doing it.
Right. You complain up.
Then
right?
once we open the doors, then I'm on your team and we're doing it the way we got to do it. But if she's going to retaliate against me for having that, then, or let's say it's you and I, you do it and she retaliates against you. that's going to stifle me. I'm not going to be, I would say, whoa, she got rid of Brad. Why would I stick my neck out? I'm just going to have to, I guess, go along with her, or I'm going to get out of here. I'll go back, work on a shift.
Yeah.
You know?
Yeah. So it'll be interesting. I think the judge will have some, questions as to, would I be, if I side with the chiefs, would I be encouraging internal discord, internal disharmony, and be fostering, okay, you're free to complain all you want and there's nothing they can do about it. And I think in the background, that's what's going to be going through the mind. And I think the mind of the courts is the employer is always right. As long as an employer makes a decision telling them they're unqualified just because their people think they are more qualified, right? But this to me would be like promoting a general, or promoting someone to general who's never been in the armed forces. Congratulations, you're a general because you were good at something else.
Exactly.
And I get it, but nonetheless, the city, look, there are cities who appoint police chiefs who have no service in the armed services, right? So but what are you going to do? You're going to tell them, well, because you don't know any better. I think the courts are going to have a lot to wrestle with.
Let me quote from the Ninth Circuit. Okay, it is at the ballot box then that New Yorkers must hold the city accountable for their deliberately indifferent actions. Okay, just change the script a little bit. And that, you know, that may be the end of the day, that at the end of the day, it was the mayor that put her there. And, you know, that may be the, you know, the quote of the day.
Yep. I agree with you. That's it for us.
Right. That's it. And please, if you haven't already, please click like and please subscribe. We're close to hitting that 1,000 subscriber benchmark. It's really important for us in terms of our ability to keep doing this. So we really appreciate the support. And Brad, it was great seeing you last weekend. It was fantastic. You know, it was a good time, and hopefully everyone got their fill of fire law issues. So
it was so much fun to do this live with you, even though we put up some of our recorded stuff about the stripper. It was so much fun. I hope our listeners enjoy this. This should give some good debate to people and, you know, around the lunch table. So I think that, you know, it's good fodder. It's also really good education for fire service professionals to watch this. If I'm in my, I know it's self-serving, but if I was in my department or chief of department again, I would say, you know what, watch this. We'll give you credit towards professional development because this is real life. All
right, man. Well, we'll see you again next week. That's it for another edition of Fire Law Roundup.